Our speaker is Keren Zwick. She is Director of Litigation at the National Immigrant Justice Center. She's going to describe a lawsuit that her organization and the ACLU filed in federal court in Chicago, in which they are seeking to have hundreds of persons who are detained in ICE detention centers by ICE and the Border Patrol and have them be released because they were arrested without a warrant or probable cause in violation of a federal consent decree. Keren will describe that litigation, which is ongoing both at the District Court and at the Seventh Circuit Court of Appeals.
Thank you for having me. And you, in fact, are very hot off the presses because this is the first public speaking that I will have done since we got the decision late yesterday. Let me back up though and maybe give a little bit of a history in this case for those who are unfamiliar with it. So in 2018, during the first Trump administration, when there was a large-scale enforcement operation conducted by Immigration and Customs Enforcement in Chicago, we filed a lawsuit challenging that practice. The main argument in the case was that people that under the Immigration and Nationality Act, Section 1357, ICE needs to have probable cause not only that a person is unlawfully present in the United States, but also that they are likely to be a flight risk before they make an arrest, a warrantless arrest. Our principal argument at that time was that the agency did not have probable cause as to both of those two factors, and they were instead making impermissible warrantless arrests. We won a motion to dismiss in that case back in 2019, and then still the Trump administration entered into settlement negotiations with us. Those negotiations took quite a while. The settlement negotiations concluded in May of 2022 with a consent decree that was to last for 3 years. Under the consent decree, DHS is required to have probable cause as to those two factors and train their officers that they need to have probable cause as to those two factors, and also importantly to document what is the basis for the probable cause, especially as to flight risk, and consider things like a person's time in the United States, their employment history, whether they have family ties, those kind of things as part of the probable cause determination, and they're supposed to document that in the moment. In January, before the inauguration, we started hearing news that I'm sure all of you heard as well, that Chicago was going to be ground zero for enforcement operations conducted by immigration, and they were basically openly saying that they had no intention of continuing to comply with the consent decree, even though it was still binding and in place. It was set to expire in May of 2025. So late January, after the inauguration, sure enough, agents began making arrests, warrantless arrests, and they also started doing this thing where they would carry around a blank administrative warrant. It's called Form I-200. And they would fill that warrant out in the field after they had already placed somebody under arrest. In other words, a person was in their car in handcuffs and they were filling out the form. And the reason they were doing it that way is because it would therefore allows them to argue that they had a warrant at the moment of the person's arrest, even though the person had already been arrested by the time that they completed the warrant. So we filed a motion to enforce the consent decree in March, and then we also filed a motion to extend and modify the consent decree. On October 7th, Judge Cummings in the Northern District of Illinois granted those motions. He found that 22 of the 26 violations that we raised were indeed violations of the consent decree, and he ordered the government to comply with the remedies that are under the consent decree as to those individuals. And he also extended the consent decree for 118 days to February of 2026. The duration of that time, interestingly, was based on an email that the Office of the Principal Legal Advisor for the Department of Homeland Security issued to its officers while the case was pending, basically instructing the officers to stop following the consent decree and the nationwide policy guidance that was entered into as part of the consent decree. So basically in June, while our case was pending in front of Judge Cummings, the government blatantly said we were no longer going to follow this. And so Judge Cummings calculated that 118-day period from the date of that order, and basically said you guys are entitled to recapture that amount of time where the government was wrongfully violating the consent decree. And that was how we got to the extension. As I said, that decision came on October 7th, and the judge on October 7th also ordered rapid fire production, because by that point there had been more than 1,000 warrantless arrests in Chicago, and we were trying to get remedies for individual folks who had been arrested. And so the judge ordered the government to engage in ongoing production. The government then sought an 8-week extension of that production, which we opposed on numerous grounds, principally that in those 8 weeks, they were going to remove people from the United States or force them into taking voluntary departure, and that it was not appropriate for them to drag their heels in that way because it would mean that people would never be able to get the benefit of the agreement despite having suffered a violation. So after a lot of back and forth and a lot of briefing in front of Judge Cummings and a hearing, we had a hearing on November 12th. And at that hearing, the judge indicated that he intended to order the government to release anybody who was a probable violation of the consent decree who still remained. And if you've been following the media of this case, the number that gets quoted is 615. The way that that number was calculated was that the government had, in their product, had said that they believe that there were 1,800 people who were probable violations or possible violations of the consent decree. But by the time we produced that number in mid-October, and by the time we had a hearing on November 12th, only 615 of them or so remained in the United States because 2/3 had already either been removed or taken a voluntary departure or been coerced into accepting a voluntary removal from the United States. So the judge ordered as an interim remedy that people be released on ankle monitors and with a $1,500 bond while we engaged in the dispute resolution process to ascertain if there was a violation. And then that order came on November 13th. The government then promptly appealed. That went to the Seventh Circuit, and they sought a stay pending appeal of both the October 7th order and the November 13th order. And then the Seventh Circuit ordered expedited briefing on the stay. They granted an administrative stay pending the consideration of the stay. And then we had oral argument last Tuesday, on the government's motion for a stay pending appeal. And then just yesterday, the decision came out in that. In the decision, the Seventh Circuit, there was a dissenting opinion from Judge Kirsch, but Judge Lee wrote for the majority. In the decision, the court denied the government's motion to stay the October 7th order regarding the extension of the consent decree. So that's really good news, that the consent decree remains in place at least until February 2nd. On the less good news side, the court did grant the government stay pending appeal with respect to the interim relief requested and the release of people. Now, in that second category, the court divided it up because some people who had been arrested at that point were arrested pursuant to these 200 administrative warrants that I mentioned before that were filled out in the field. For those people, if they have one of those, then there's a stay pending appeal for the full duration. But the stay pending appeal for the remainder of the class is only until we can engage in dispute resolution, because our argument at the Seventh Circuit was that most people were just blatantly warrantless arrests. They didn't even try to do this. They didn't even try to use this, what we believe is an illegal cure, by issuing a warrant in the field, and they just were pure warrantless arrests. And so for anybody who falls into that second category, which we believe is the majority, we are supposed to now begin dispute resolution process to get them released imminently. The court also did, however, stated the implementation of the decision for 14 days because the government asked for that so that they could seek appeal to the Supreme Court. And also the court ordered that there would be expedited briefing at the Seventh Circuit on the merits of the overall appeal. This all happened yesterday, so we don't really know what will happen next. So we're trying to prepare for the possibility of having to brief the stay at the Supreme Court at Christmas time, and also the possibility of having to engage in rapid fire individualized dispute resolution for the people who are victims of warrantless arrests, and a number that has now climbed to, we believe, more than 4,000 people. So that's where we are. You're like thinking about what it means to lawyer in 2025, like the epitome of the roller coaster. In this case, we had like a hearing on November 12th. We had a brief due on November 16th, and we had another brief due on November 19th, and we had an oral argument on December 2nd. So it's rapid fire. You have to do a lot on your feet. Back in July of this year, the government had taken the position that any person who entered the United States without being inspected at a port of entry was subject to mandatory detention, which was a change in policy for the entirety of the existence of the statute that they rely on. It had never been interpreted in that way. And many, many federal courts have rejected this argument, and habeas petitions. There have been more than 700 habeas outcomes, and more than 20 different judges in the Northern District of Illinois have weighed in on this. The court did say that the proper remedy for an unlawful arrest in our case is release, and that unlawful interpretation of mandatory detention should not be an impediment to release for people. The good news about that is that once we actually are able to begin the individualized assessments, people should not face that additional burden, which is one of the arguments what the government was presenting when we were back in front of Judge Cummings earlier this year. I can keep going, but I'm happy to field questions.
Anyone have questions for Keren?
I have a question, Keren. How are you managing the need to handle the dispute resolution on I think you indicated roughly 4,000 people that'll be going forward now?
So I think for right now, we need to wait and see if the government appeals to the Supreme Court, because if they appeal, then that dispute resolution process might not actually begin. If they don't appeal, then we'll start talking with them about how to go about it. Before they appeal, they had started producing certain things that we need to begin the individualized process. So we're in the process of sorting through the information that we have to see what we need in order to undertake that process. But it certainly will be a big endeavor if and when it is able to begin.
Are you looking to get volunteer attorneys, or do a lot of these people already have attorneys?
Most people do not have attorneys for their underlying immigration cases. I will say that of the 4,000, I suspect that a substantial number of them have been removed already, and that number will continue to grow. If people are interested in representing individuals in their immigration cases, that's a separate matter. And like we at the National Immigrant Justice Center, we do a separate part of our office. We do a lot of that direct representation of people in their immigration cases. And we are part of this broader coalition called the Midwest Immigrant Defenders Alliance, which includes a number of different Chicago-based nonprofits. And then we're also part of a coalition that has been started with the American Immigration Lawyers Association and others to recruit private counsel for folks who need it for that purpose.
Thanks.
Any other questions?
What's the deadline for filing before the Supreme Court, or is it just as soon as possible?
They got a 2-week stay, which 2 weeks from yesterday will be Christmas Day. So,
So their response is due Christmas Day.
Officially, yes. I suspect that they might file earlier than that in order to have to file on Christmas.
Right. They may file something on Christmas Eve.
Thank you.
Okay, another excellent presentation. So very, very informative. And I extend the invitation to you to stay with us longer if you wish.
Thank you.
The next couple items on the agenda.